Baseball scholarship to the. They selected like 6 or 7. Yeah.
Yeah. I didn't post that.
So you need to go along with that.
Pretty sad. Yeah.
But the council here.
It's a little.
Yeah.
I think. And that's her.
That we never calculated. Right, it's interesting.
Well,
Yeah.
yeah.
All rise. Court of Appeals of the State of Kansas is now in session.
Thank you. Be seated, please. Good morning. My name is Gordon Atchison. I'm presiding judge today on our docket. We have one case set for argument. We'll get to that in a moment. In the meantime, I would like to introduce my colleagues. To my right is Judge J.C. Hurst. She is a KU law graduate. She joined our court in 2021. Before that, she had an litigation practice in the Kansas City area, focusing on business and healthcare. To my left is Judge Rachel Pickering. She is the newest member of our court. She joined us in January of last year, most immediately from the Shawnee County District Court bench. Before that, she litigated in various capacities in the public sector that I won't run through all of those. She is a University of Missouri law grad. We don't hold that against her. I also graduated from KU Law School. I had a litigation practice on civil criminal matters for 29 years, first in Wichita and then in the Kansas City area before I joined the court. And I'm about to start my 14th year on the court, which if you add all of that up, makes me kind of old. As I said, we have one case on the docket today. It is Otis and Nauser et al. Versus Attorney General Chris Kobach et al. Case number 127-124. I will tell counsel, although you all are experienced appellate litigants, we obviously have read the briefs. We are familiar with the arguments in the briefs and generally the factual circumstances out of which this case arises. It has been set for the standard 15 minutes. If the appellant would like to reserve a portion of that time for rebuttal, please tell me at the start of the argument. Because it is the only case, and I think given the issues involved, I'm not going to strictly enforce the time limits. We'll go till those of us up here run out of questions or funny stories to tell. But be advised that, I mean, there is an outer limit. With that, we'll go ahead and hear from, we have the timer set up. Okay. I will keep time on my smartphone. Hopefully it's smarter than I am, but I think I could manage that. If the appellants would like to, counsel for the appellants come forward. Well, one of the, whoever's arguing, I don't need both of you.
Well, may it please the court.
Judge Powell, welcome.
Solicitor General, it's good to be back. I wanted to introduce counsel, Mr. Mercer Martin, who's with Alliance Defending Freedom, who will be arguing the case.
Oh, all right. I thought
introduce him to the court.
the Attorney General might send the A-team, but I guess just to do the introduction, you're more than welcome, and I'm sure you will be more than capable. So hang on just a second here.
All right.
Um, Mr. Martin, would you like to reserve a portion of the 15 minutes for rebuttal?
I'd like to reserve 4 minutes if I could, Your Honor.
You have it. Let me adjust my. Please proceed.
Good morning, Your Honors. When presented with competing experts, a district court has an obligation to analyze their testimony for reliability, relevance, and accuracy.
You said competing. Does that matter that it's competing when the court looks at the reliability of the expert's opinion?
I think it does matter, Your Honor, that there's competing experts here.
Does it say that in the statute when we look at Daubert findings? That we look at competing? Does that, the district court's analysis is competing, or is it looking at the reliability of the scientific principles for which the expert opinion bases their testimony?
The obligation to analyze the reliability under the Daubert standard and for admissibility, that is the same whether there's competing experts, Your Honor. The reason the competing experts matter in this case is because as a fact finder, the district court also has an obligation to analyze the experts' reports for accuracy, for the methods, which is correct when we're dealing with these highly controversial medical questions. And so when there are competing experts, the district court has an obligation to show its work, to explain why it decided the way it did. And in this case, the court's explanation was simple. It was credibility. And it relied extensively and nearly exclusively on credibility on these highly controversial and disputed questions.
And this isn't a ploy to exploit the argument. I'm a little confused by the state's argument about the need for the district court to have conducted some kind of a Daubert or 6457 threshold determination, given the procedural posture that the case was in front of the court. But you refer to that extensively in the brief. How does that advance your position here?
It advances our position, Your Honor. We're not necessarily arguing that their evidence needed to be excluded or that there needed to be a Daubert hearing. What we're arguing is that the district court, when evaluating the experts, needed to show its work and needed to make some determination as to these questions, as to reliability, relevancy, and accuracy.
Wait, so you're assuming then, by your argument is that the judge assumes, although it's not raised below, that he or she needs to make a Daubert finding in their analysis. Is that your argument?
The court doesn't need to make an explicit Daubert finding in regarding to admissibility, especially when it's acting as a fact finder.
And especially since neither party requested a Daubert hearing or a Daubert evidentiary analysis by the court. Is that correct?
It's correct, Your Honor. Neither side requested that. What we are arguing is that at the very least, the district court needed to make some sort of analysis as to the underlying principles presented. What the court did instead was, again, rely on credibility and mostly.
Reliability is a threshold gatekeeping mechanism, right? And so theoretically, if the judge did not find the testimony reliable, then the judge would have excluded the testimony as in a Daubert hearing, right? Said, no, I'm not going to consider this evidence. Can't be presented to the fact finder, et cetera, right?
Generally, yes, Your Honor, that's correct.
So I think I'm trying to understand what it should look like.
Mhm.
So is there a checklist that should be done in this type of proceeding for reliability versus credibility? Because you're saying that this argument is related to reliability, not credibility. You're not questioning the judge's credibility determination.
Your Honor, we are not, we are questioning the credibility determination,
Okay.
the viability of that determination. And we're not arguing that there needs to be a certain checklist that the court needs to check off when it writes its opinion. The error here, and I'll point the court to the decisions in Campbell and Andrew, in those decisions, there was an analysis, far more than in this case, of the underlying medical opinions that were presented.
Can we agree, though, that those are so factually distinguishable from this procedural posture and the question being asked of the court? In those cases, the court was actually being asked to determine the factual answer, right? In those competing experts' testimony.
I think here the court was also asked to determine the factual answer that was presented. For example, and I think the question that it answered was, are there certain compelling interests that are advanced by this act? A significant one is maternal health. And the competing experts, the state made a factual answer on that, or excuse me, the judge made a determination on that question based on the competing facts presented. It determined, for example, that Tylenol is safer than a medication abortion. And so I do think that
It determined that the credibility of the expert putting forth the argument that Tylenol was safer than a medication abortion was more credible than the other one. That's what it determined, right?
it determined that, but the way that it stated these conclusions were in its findings of fact as facts, and then it relied on those facts.
So do you have an example in a TRO, state, federal, of a reliability requirement that you're suggesting should happen here?
So
I looked, so I'm curious. I want you to, I can't.
Your Honor, I don't have a factual parallel from a TRO proceeding that had this kind of error that was addressed. But I would argue that the nature of the hearing doesn't matter when it comes to this kind of legal error. When it comes to credibility determinations, I would argue that the fact that this was a temporary injunction hearing makes the credibility finding actually all the more egregious.
Oh,
And-
I'm
How
gonna-
are how are you defining credibility?
That was my question, because we see
Well, that's
credibility of
brilliant
expert.
minds operating together. I mean, what are you talking about when you're talking about credibility?
Credibility, as this court has explained.
No, I'm asking you what you're talking about when you're saying the judge made credibility findings that he didn't, I mean, are you saying he can make them or shouldn't make them on this record?
It is inappropriate on this record to be making credibility findings.
Because it's submitted on declarations?
Correct,
All
Your
right.
Honor.
So let me back up. I would like to know how you're defining credibility for the purpose of your conclusion that it was inappropriate.
Credibility is a determination of truthfulness, of candor, of if we can believe the facts presented are true based on the individual presenting them, as opposed to the underlying statements that
All
they
right.
made.
So let me see if I've got, I mean, you're looking at credibility as honesty.
Yes, Your
correct?
Honor.
Okay. So like, it's much easier conceptually with a fact witness, but the fact witness comes in and is honestly attempting to recount what they have seen or heard. Now, they may be mistaken, but they're honest brokers, right?
Correct.
Okay. And the same applies here, is you're talking about credibility as to whether these experts are honest brokers,
Correct.
in the sense of they believe the opinions that are in the declarations.
Yes, Your Honor.
Okay. And that they're not just bought and paid for, and in another case, they would say something else if the other side wanted them to. And I take it by the premise, I mean, we're dealing with honest brokers on both sides, right?
Yes, Your Honor. We certainly wouldn't object to. We're not here to certainly to object to the credibility of the other side's experts. No.
Okay. That, and conceptually to me, that is distinct from reliability of the opinions. Would you agree with that?
Yes, Your Honor.
I mean, you can have an honest broker, the opinions may or may not be reliable for various reasons. Is it your position that in the posture of this case on competing declarations in a temporary injunction hearing, the district court could make reliability, at least some reliability determination.
Certainly, Your Honor. Yes.
So, I mean, if we look at the opinion, I almost, it seems to me like we're getting into a word game, is that the judge said credibility, and you don't like that. If the judge was considering credibility as a broader concept, and it does seem to me that credibility can include both being an honest broker and being reliable. I mean, certainly with a fact witness, both of those go into whether the witness is credible. I mean, somebody says they saw X, Y, and Z, but it was dark out and they didn't have their glasses on, the whole, 12 Angry Men business. You're too young to know what that is.
It's a great movie if you haven't seen it yet.
I'm also too young.
But those are bound up in a broader notion of credibility. And was the district court judge here really saying these folks are dishonest? Or was he saying, I have looked at, to the extent I have this stuff in front of me, I'm functionally really making a reliability determination. And he just used a different term or a broader term.
I would argue, Your Honor, it's difficult to tell exactly what he meant when he used the term credibility. But that language is important because when you use the term credibility, and the judge used it, I believe, 23 times.
Oh, it's in there a lot.
In the opinion.
Yeah.
When you consistently use the term credibility, and this is the crux of the issue and the error, is that acts to insulate the decision from appellate review.
All right, I'm going to stop you.
I'm sorry.
It's okay. I want to stop you there and I want to just take it a little bit further.
Yeah.
I'm reading point of the judge's order, point 52. There is no credible scientific medical evidence. Isn't the judge looking at credible evidence versus credibility of a witness, which is very different? We understand as appellate court, we defer to a district court's findings on credibility. They are there. They can see the person at the witness stand. Versus this judge was presented with expert opinions based on scientific principles. In that he weighed, and in that same point, he says, indeed, the overwhelming weight of credible evidence. So isn't the judge doing exactly what he's supposed to do by weighing the evidence and finding one more overwhelming weight of credible evidence versus the other?
If the judge were truly looking at the underlying evidence, let's say its accuracy, I don't think the judge would have used the term credible evidence. And later on in the opinion, there is one footnote where the judge does attempt to explain these credibility findings, and it refers to, for example, flamboyant rhetoric. So that doesn't seem to suggest that the judge was looking at the underlying evidence as to its, again, reliability and those kind of factors.
Well, are you saying that a judge couldn't look at one expert opinion, notice rhetorical language in it and think, man, that's less reliable than this evidence over here that has all of this data that seems to have less rhetoric in it?
If the judge were to do that, there needed to be a fulsome explanation for that.
Okay, so if we had this, because we're looking at a 92-page opinion from the district court. I want to say kudos, we don't often get a 92-page district court opinion. And so if the judge had used the word reliable instead of the word credible evidence, because he's not saying, and I say he because it was a he judge, that the witnesses weren't credible, right? Didn't say they lacked degrees. They have degrees. They have fabulous looking degrees and they teach at fabulous institutions. But when this judge had said credible evidence, I'd be interested in a sort of dictionary definition of the difference between credible and reliable evidence when you're saying credible evidence, reliable evidence. So if this 92-page opinion substituted those 20 credibles with reliable, would we be here having the same argument?
Your Honor, I believe we would still be here because I think this issue is twofold. One, it's the consistent reliance on credibility.
Okay.
And I do think that the term credible evidence is referring to the experts themselves. But I will
How
also.
so? How do you make that leap? Because I'm not with you on that. So help me get to where you are from credible evidence to credible witnesses. Help me with that because credible witness gets to a judge's gatekeeping role before he presents their expert testimony to the jury. So help me make that leap. I see it as a leap. Please explain.
The way you make that leap is you look at, did the court give any other explanation to defend this, let's say, potentially reliability finding? The court didn't. The court largely copy and pasted conclusions from the experts, and it did not give an explanation as to why, for example, why childbirth, why abortion would be safer than childbirth, for example. It's a conclusion that it made, or why Tylenol is less safe than, or is less safe than abortion. These are highly contested factual issues that the expert spent considerable amount of time discussing, and the court did not give.
Back to the sort of flamboyant rhetoric. I mean, the comparison of medication abortion with Tylenol. I mean, I understand it was debated back and forth. It seems to me that in and of itself is sort of a sidelight. I mean, that may be a polemic statement by the plaintiff's expert. I mean, you have a certain amount of polemic discussion, frankly, in the declarations from the state as well, and the judge has to kind of cut through that. So, I mean, I'm not sure I see quite where that gets you particularly.
Right. So I'll give another example, Your Honors, which is the 2023 amendment dealing with abortion pill reversal. The court, in its introduction on that issue, summarily said that there is no credible evidence that the abortion pill reversal theory is safe and effective.
I would argue that the state put forth credible evidence that the reversal theory is effective.
Correct, Your Honor.
So what then we're looking at is the judge. Is it your argument that the judge didn't consider the state's evidence, or is it what it looks like, which is the judge considered it and thinks this evidence is better than that evidence? I mean, that's what they're supposed to do.
I would argue the judge really didn't consider it.
Okay, so then I have one more procedural question. I apologize for kind of cutting it short. There is something you could have done to ask for a more clear understanding of this rule before. Right?
I think this was the procedural posture that was followed in Campbell and Andrew, Your Honor.
But those are federal cases, aren't they?
They're federal.
Okay,
right.
and this is a state case.
There's rules where you can ask the judge to put forth a more statement. You can,
Yeah, I'm not, what is it you're drawing from Andrew and Campbell? I mean, I've looked at those. I mean, that's it's an administrative scheme. You're talking about a trial on the merits of causation and stuff. And you rely heavily on that. I guess I'm not sure, other than the statement by the appellate court that you can't mask a legal conclusion under the rubric of credibility, which they're talking about honest brokers. What else do those cases do for you?
The other similarities there, Your Honor, is in that case and this case, you have competing experts. There is no question as to their authority to speak on these matters, as to their credentials, and you had a similar error where the court was presented with really difficult medical questions to answer, and it responded. And in those cases, the courts did more because they did actually speak some to the experts, but then said, but I find one side unreliable. And that was the legal error. And that is highly analogous to what occurred here. And to go back.
Well, I mean, in your position that the judge didn't explain it. I mean, he could have, but he didn't.
Right, Your Honor. It's But that goes back to the additional error here, which is that unlike in those cases, this was again decided on a paper record. So it would be difficult to see even what an explanation on credibility would look like in a case such as
Well,
this.
all right, but as you're defining credibility, I'm not sure he made one, but I mean, you're saying he could make at least some reliability determination based on the record.
A reliability determination,
Are you
yes.
saying he can't or he couldn't?
He certainly could make a reliability determination.
And ultimately, what is it you want us to do here?
Yes, Your Honors, our request is that the temporary injunction be reversed and that this case be remanded back to the district court for the court to make factual findings after a full review of the evidence and provide reasoning that doesn't have this legal error of relying just on credibility.
And what
Right.
you're asking us to do is something you could have asked the district court yourself if you'd followed the motion to modify or amend, which allows you to do it within 28 days. Am I right in that? And here you filed your notice of appeal 14 days after court's order. So you're within that timeline to file a motion to modify. Instead, you filed an appeal. And so time has been spent on this issue.
You're right, Your Honor. Again, we were following, and I understand those cases are different procedurally, but we were following the precedent we were aware of, which was appeal and reverse the temporary injunction. Because again, the state has a significant interest in enforcing this act in the interim.
Would it be appropriate to leave the temporary injunction in place and remand for factual findings?
I would argue that wouldn't be appropriate when there's a legal error that forms the basis of the decision.
Well,
But what
we don't know
legal
if
error?
there's an error because, I mean, your position is he didn't explain himself well enough. We send it back and say, hey, district court judge, you didn't explain yourself well enough. Explain yourself. In the meantime, why should we reverse the temporary injunction on the assumption he can't explain himself?
Relying on credibility in this manner, that is what justifies legal error. And that underlied each of the analytical points in this.
The other question, why should we send it back at all? Why can't we make the determination?
Your Honor, this court that would be against this court's typical precedent of not partaking in fact finding and going through the evidence in the first instance.
Well, I beg to differ with you. I mean, the facts here are set out in declarations that we can review just as well as the district court, right?
That's true, Your Honor.
And we can make reliability determinants just as well. Why not cut out? I mean, because we'll send it back and he does whatever he does, and one side or the other is going to appeal it back to us. Why don't we just cut out that step and do it ourselves?
The reason is that it is true that these are paper records that we're dealing with, but they are highly extensive. And this is normally, that kind of fact finding is normally
All right,
done.
but what's he going to do that I'm not going to do?
It's not that you, Judge, could not do that kind of analysis. Certainly you could on a paper record, that makes sense. But it's simply a matter of, this is typically the purview of the district court, is that intensive fact finding and analysis. That
in other cases where we've got a record that consists of either undisputed documents like a contract or declarations, we make a de novo review anyway. Why can't we just make a de novo review of this and not burden everybody with sending it back?
I think, Your Honor, that would burden this court more than necessary. I think this is different than declarations or a contract where, we might be talking about he said, she said declarations or one contract that can be reviewed. These are 7 experts from the state, and I believe 4 from the plaintiffs. It could be more. And that is the kind of analysis and fact finding that is normally the purview of the district court. And we argue the best place for that to occur.
One head is better than 3 then.
No, Your Honor, it just puts this court in its typical position of reviewing robust factual
Well, but
findings.
it's not atypical. I mean, I've
Had a
done
tax
that in
appeal
other
recently
cases where-
regarding value of property involving competing experts.
And certainly this court, I'm sure, often has to look at those expert reports in review. But the problem here was that there was so little explanation done. Again, it was just, this court really accepted all of the plaintiff's evidence.
When you submit the experts' reports and you do not ask for evidentiary hearing, aren't you asking for the court to make exactly what you're complaining about now?
No, Your Honor, even when there is not a Daubert objection
Or even an evidentiary
or an evidentiary
hearing whatsoever?
Well, no, Your Honor, because what the court did was the opposite of what should happen on a paper record, right? On a paper record, the court still has all the evidence it needs to look at, this is what one side said about abortion per reversal, this is what the other side said, here's what I think is right, as a matter of fact. Instead, the court simply relied on credibility.
So I think it sort of comes down to the idea that because the judge used this word credible, your contention is that the judge somehow thought the state's witnesses were dishonest people. And when we look at the word credible in here and we see it describing evidence, it could mean something different than what you think it means. And my issue here is that I'm remiss to find a rule requiring the court to do what you said the court is required to do. Because there was no request for a hearing, because there was no request for Daubert, because there was nothing, there isn't a rule that says the court has to make a robust reliability determination on the record. I mean, frequently we'll get a 2-page opinion from a district court. So there is no requirement that I'm seeing for the judge to do what you're saying the judge needs to do. And so even if we send it back, it's difficult for me to say, all right, well, this is what you're supposed to do, because it looks like the judge did what they were supposed to do. There was competing evidence and the judge picked one.
The problem here, Your Honor, first, I would point to KSA 6906 that the court must give specific reasons for its decision on temporary injunction. And I think in this instance, when we're dealing with competing experts, what was that, Your Honor?
92 pages, specific reasons.
As to the experts, it did not give specific reasons. And this is why this issue is two-pronged. It's not just that the court didn't do a robust enough analysis, and I understand the court's reticence in that regard. But secondarily, it was that not only did it not do that, it then relied on credibility. And that was its basis for all of these factual findings. And that is what hamstrings the state going forward in this case. And so it's not that...
What are you hamstrung by at this point?
The reason the court is hamstrung is that all of these fact findings that were essential to the court's legal analysis are entirely one-sided. It's all the plaintiff's experts, and the state is now not in a position to address any of these factual findings because their experts have been found not credible. And in such a circumstance, that's no longer evidence that you can bring forth at appeals going forward.
So you're saying that you can't argue that the district court incorrectly found a factual finding?
Well, that factual finding is largely insulated now.
So then let's say we send this back and then the district court changes these words to reliable and adds the word because and puts a long paragraph explaining why the district court didn't like your witnesses. That puts you in a better position?
I do believe I do not believe the district court would do that, Your Honor. I think that if he were to look more fully at these reports, he would very likely come to different conclusions on the facts. But even if he didn't, and he did what you described, that would be a better position for the state. Because going forward in the procedural process, the state would at least be able to raise to higher courts this is, take a second look at these factual findings, many of which I believe could be found clearly erroneous.
Mr. Martin?
Yes.
Did you use the word hamstring just a moment ago?
I believe so.
And what was that point of that argument? I don't understand.
The point is to say that because the district court relied extensively on credibility,
Right.
that has essentially left all the factual findings on one side. And on appeal, those are now all given deference.
Okay. So in the court's order, and I'm reading from it, hereby enjoins the defendants from enforcing, and it lists the statutes, pending a full hearing on the merits on plaintiff's request for a permanent injunction and declaratory judgment. How are you hamstrung by the court saying pending a full hearing on the merits? In other words, this is just phase one. There is still a full hearing to be done.
Phase one is still very significant, Your Honor, because the grant of a temporary injunction, why the procedure may be more expedited, and we're not objecting to that.
While the procedure, what? Couldn't hear you.
Sorry, Your Honor, while the procedure may be more expedited than a full hearing, and we're not objecting to that procedure, the grant of a temporary injunction is still significant now because the state has a strong interest in enforcing its act and the interest in protecting women and ensuring that they receive informed consent. And so we are hamstrung now in dealing with the temporary injunction.
It seems like that's a pretty good argument for us to resolve it rather than sending it back, isn't it?
I think, Your Honor, that by sending it back, I think that the proper procedure would be to reverse the grant of the temporary injunction. And then I think the court, having already handled a lot of this evidence, could
Is
expeditiously.
that typically what we do, though? I mean, when we send something back for more fact findings, because that happens sometimes, although there is a different process for this. There's 2 rules on it. Do we reverse, we let the defendant out of jail and then send it back for more fact findings on why the sentence was appropriate, et cetera? Probation revocations, we unrevoke the probation and then we send it back for more fact findings on that. I mean, is that what we typically do?
I'm not fully familiar with criminal procedure, Your Honor, and how the court normally operates there, but I do think this kind of legal error, when the entire decision is based on a legal error, I do think that then it's appropriate for there to be a reversal and for there to be additional fact finding to be conducted.
Legal error is a violation of what?
The legal error is relying exclusively on credibility to,
Because there is a statute, common law, something that says you can't rely on credibility on a paper record.
yes, Your Honor, I would point this court to its decision in
Aeroflex?
Yes, Wichita Aeroflex, which talks about the deference given to paper records and that sort. So that would be the rule I would put the court to.
All right.
Deference given to paper records. Deference that we should not give. We do not give deference to the district court, correct? When there's paper record.
When there's the Kansas Supreme Court has not on the issue of a temporary injunction decided that explicitly. So technically it's unclear at this stage whether such deference is warranted. The reason we bring that up is to show the egregiousness of the credibility finding, to show that when there is a paper record, credibility is really not at issue.
And appellate courts do not give deference to the district court, correct?
Typically they do.
Right, but when they're looking at simply a paper record, they do not give deference to the district court's findings, correct?
Ordinarily, no.
Right, which would segue into Judge Atchison's question of why can't we then consider it, since you're saying you don't give deference to district court's credibility findings because it's a paper record, and here we are with a paper record.
Again, Your Honor, the reason that we are asking for a reversal is because of the extensive nature of these expert reports, the fact that they are very long reports, many of them highly contested issues that are best typically.
That's not a very persuasive argument.
Sorry. I mean, you're saying we can't read the expert records because they're too long.
Yeah, don't go there with that.
I apologize, Your Honors.
Well, I'm just saying, I mean, you're sort of saying you guys can't figure it out. I mean, that's not a good argument to make to us.
I certainly believe that Your Honors are able to review these reports.
You just don't want us to.
The reason we fully trust this court with reviewing these reports.
Stop. I appreciate that you trust this court. Go ahead.
The reason that we made this request was based on the typical purview of an appellate court and the typical purview of a district court. That is the reason.
You got anything else at this point?
No.
Okay.
Not at this point. Thank you for
Thank
answering.
you. You still got your rebuttal time. And you can sit down now. We're done with this part of it. And we'll
Thank you,
hear
Mr. Martin.
from plaintiff's counsel, and you got a boatload of time if you want to use it, but we don't, I mean, I'm going to even out the time. So he went on at some length and you can have the same amount of time, but don't feel obligated to use it.
Thank you, Your Honor. Good morning. May it please the court, Alice Wong for Plaintiffs Appellees. We're here today on an appeal of a temporary injunction in a case that is currently in ongoing discovery on the merits. The state has provided no basis to reverse that order, and it should be affirmed for 3 reasons. First, the state fails to challenge the district court's findings of fact and conclusions of law. It does not contend that any of the district court's findings are unsupported by substantial evidence, nor does it suggest that the district court erred in applying any of the temporary injunction factors. That should be the beginning and end of this court's review.
Are you saying we don't have jurisdiction?
No, Your Honor. I'm saying that the correct standard of review for a temporary injunction order is abuse of discretion. And where a district court has made findings of fact and conclusions of law, this court reviews the findings for substantial evidence and looks to see whether the legal conclusions are adequately supported with a factual basis.
Yes, but the standard review of abuse of discretion does include also that the district court failed to follow the law. And isn't that their argument, that the district court failed to follow the rules?
Your Honor, the state attempts to invent a legal error by mischaracterizing the district court's fact-finding as a failure to gatekeep, but that distorts Kansas law and the record. Evidentiary gatekeeping is simply not at issue in this appeal, where no party challenged the admissibility of expert testimony and no evidence.
I mean, I think his argument or the state's argument kind of goes beyond that at this point and is really attacking the district court's, what they're terming the credibility finding. I mean, what's your response to that, the district court erred in expressing what it did as a credibility finding?
Your Honor, the state's contention that the district court erred by making credibility determinations based on a paper record is incorrect for many reasons. First, the state's claim that credibility is only about a witness's truthfulness and not about the reliability of expert testimony flies in the face of Kansas law. In State v. Stewart, the Kansas Supreme Court explained that district courts are frequently called upon to resolve competing evidence. When presented with conflicting expert testimony, a district court is required to assess the credibility of witnesses and weigh the evidence to make findings that comport with one opinion and contradict the other. That is exactly what the district court did here. It was entitled to and indeed had to trust one expert's opinion over another to make findings based on conflicting expert
Does the district court really
testimony.
have to trust an expert's opinion? I mean, aren't you going a bit far in that usage?
What I mean by that, Your Honor, is when presented with conflicting expert testimony, the district court necessarily has to decide whose opinion to give credence and whose to disbelieve. That's the only way that it can make a finding that rests on conflicting expert
The district court
testimony.
didn't say he disbelieved the other, the state's expert witness. He just said it weighed the experts' conclusions. Didn't he talk about weighing them
Yes, Your Honor, and that is the district court's exercise of its broad discretion as fact finder to consider and weigh the evidence, including resolving conflicts in expert evidence.
Okay, I think we all agree that the district court has that responsibility. I think one of the arguments I'm hearing from the state, though, is that the judge did not do a good job in that. That the district court failed to properly, appropriately, sufficiently explain that weighing. And so can you address that? Because, I mean, I will say that the district court's opinion does heavily favor one set of experts over the other. And so is the district court required to explain that more than it did here?
No, Your Honor. As an initial matter, the state's argument is a misplaced attempt to import the Daubert standard into this appeal, but no party challenged the admissibility of expert testimony or otherwise sought to exclude
No, I don't
any
think
evidence.
that's what Judge Hurst is asking you. She can speak for herself, but I mean, I think it's the next step. I mean, I don't think there is a question about the threshold reliability. It's whether the district court carefully and precisely articulated why it favored and found more reliable, essentially the plaintiff's expert opinion on certain subjects over the state's experts. It's not a threshold question. It's a question, you get beyond that, they're all in there. And whether the district court sufficiently explained its preference.
2 points, Your Honor. As the fact finder, the district court did not have an obligation to catalog and comment on every opinion that was offered in the hundreds of pages of testimony that was submitted in
No,
the
but
temporary-
I mean, in issuing a temporary injunction, didn't it have an obligation to recite the facts and then the conclusions and the restrictions it was imposing?
Yes, Your Honor, and the district court fulfilled that obligation. Its 92-page meticulously thorough opinion belies the state's claim that it didn't.
Well, I mean, it's a long opinion, and as a matter of use of the English language, it's kind of a nice opinion for the judge lawyer produced thing, but it's pretty cursory in a lot of
Conclusion.
why it comes out favoring one side or one expert view as opposed to the other.
I respectfully disagree, Your Honor, and I'll provide you with 2 examples. At our Volume 1, page 186, the district court found that the overwhelming weight of evidence suggests that the theory that progesterone therapy reverses a medication abortion is untested, potentially dangerous, and speculative. And it expressly notes that the state's experts relied on limited case studies that were not appropriately peer-reviewed, while the plaintiff's experts offered evidence that the only randomized controlled trial that attempted to test this theory had to be halted early due to severe adverse reactions. As the second example, at our Volume 1, page 216, note 28, the district court noted that it was not persuaded by the state's evidence regarding the point in pregnancy when it's theoretically possible for a fetus to experience pain because of the internal inconsistencies across the state's experts' opinions. In the district court's own words, the state's experts were, quote, all over the map.
So I think in going through this, I found a few others that were more specific than that, that were specific like that. However, there are more examples that are less specific, that are more conclusory, that are not explained as thoroughly as those 2 examples. And then I think maybe 3 more I found. So are you arguing that those 2 examples you gave me, for example, the district court was not required to do that much?
That's correct, Your Honor. The district court went above and beyond in the specificity of its findings, but it had no obligation to catalog and comment on every piece of evidence that was offered in the temporary injunction litigation. The omission of some evidence from its temporary injunction order doesn't equate failure to consider that evidence.
Would you agree with the state? In their brief, they said that the judge's opinion rejected the state's reports wholesale. Wouldn't you agree that is what occurred here?
No, Your Honor, absolutely not.
And why not? Because I went through the judge's order. I don't see where they accepted. Did they accept anything from the state's experts?
Yes, Your Honor, there is one narrow factual issue on the edge of viability where the district court accepted the state's expert testimony, but that doesn't matter. Regardless of whether it accepted any of the state's expert testimony, it had no obligation to do so because it was the district court's discretion as fact finder to consider and weigh the evidence. And the fact that it found the plaintiff's expert testimony more persuasive than the state's is not a legal error.
Let's say that we think the district court could have done a better job of explaining to us why it found one set of experts more reliable than the other set. What are we to do? The state says it's reverse the legal conclusion and then send it back for more fact finding. I said, are you sure we're supposed to do that and not just send it back for fact finding? What do you think we're supposed to do?
Your Honor, regardless of whether you reversed it and sent it back for fact-finding or did the fact-finding yourself, and even if you found that the district court erred in all of the findings that the state contests, that would not change the outcome, and this court should still affirm the temporary injunction order. That's because the vast majority of the district court's factual findings are supported by uncontroverted evidence that was submitted by plaintiffs and the Kansas Board of Healing Arts, as well as the court's judicial notice of the challenged laws.
So in order to reverse the TRO, we would have to engage in the TRO analysis and find that the TRO was wrongly granted.
Correct.
So then we would have to just do the thing.
Correct, Your Honor. And even if this court were to go through that exercise, the outcome should be that the district court's legal conclusions are affirmed because its conclusions that the challenged laws infringe the fundamental rights to personal autonomy and free speech are based on plaintiffs' uncontroverted evidence. For instance, the district court found, based on uncontroverted testimony from the physician plaintiffs, that the challenged laws delay and sometimes deny access to abortion care, and that the challenged laws force plaintiffs to parrot state-mandated messages that they vehemently oppose and that contravene their professional judgment. As the Kansas Supreme Court recently reaffirmed in Hodes and Nauser v. Stanek, any evidence of infringement is sufficient to meet plaintiff's initial burden and shifts the burden to the state to meet strict scrutiny.
Let's talk about that. Whose burden was this in this case?
In this case, it was plaintiff's burden to demonstrate a likelihood of success on the merits. And in order to determine whether the plaintiffs did that, the district court had to look to whether there was an infringement of a fundamental right, and if so, application of strict scrutiny. Plaintiffs bore the initial burden to demonstrate an infringement, and the state bore the burden to demonstrate that the challenged laws meet strict scrutiny.
Did the state realize that the burden had shifted to them in this case?
That's an excellent question for the other side, Your Honor.
Okay. Do you think the judge addressed burden enough in its court ruling? Whose side had the burden?
Yes, Your Honor.
Okay. We spent a lot of time with Mr. Martin talking about credibility. Do you think the judge could have used a better word than credible science/medical? Would there be a better word if he had not used the word credible?
I think that this panel was exactly correct, that had the judge used the word reliable, there would be no basis for the state to bring this appeal, but its use of the word credible is not a legal error. And I think Kansas law is clear that credibility is not just about a fact witness's candor and truthfulness, but it can also be about an expert witness's reliability and whether the evidence that they are offering is scientifically supported.
So I'm going to ask you the same question I asked Mr. Martin. Are we talking about credible witnesses or credible evidence?
Here we're talking about credible evidence. The district court did not exclude any expert witnesses, let alone on the basis of candor. Instead, it considered and evaluated all of the evidence that was submitted, and it found plaintiffs' expert evidence to be more credible than the state's.
Do you think the court should have in its order explained it was not finding the witnesses non-credible to ensure clarity?
The court had no obligation to do that.
All right, thank you.
With my remaining time, I'd like to briefly address the state's argument that it is somehow hamstrung by the district court's factual findings. As this court acknowledged in Hodes and Nauser v. Schmidt, fact findings made on a temporary injunction are necessarily tentative, and a district court may well reach different findings after the parties have fully presented evidence after a trial.
When is your, I apologize for interrupting, when is your date for the actual hearing?
July 2025, Your Honor,
July 2025,
next year.
there will be an evidentiary hearing in 1 year.
Correct.
Does that go forward regardless of what we do at this point?
Yes, Your Honor.
I'm assuming we'll get something done before then, but I mean, that's not dependent on whatever we do with the temporary injunction, is it?
Correct, Your Honor. It's not dependent on how the court rules here. And I'd also like to bring your attention to the fact that the state has stipulated to not enforce the Women's Right to Know Act in HB 2264 until a final judgment.
The reversibility one, right?
All of the challenge laws that were enjoined by the district court's temporary injunction order, the state has agreed to not enforce until a final judgment, regardless of how this court rules on appeal.
I think I misunderstood. I thought they only agreed to not enforce the reversibility portion.
Your Honor, the state agreed to not enforce HB 2264 until the district court ruled on the plaintiff's motion for temporary injunction. That was earlier on in this case.
Okay.
After the state filed this appeal, the parties reached an agreement for the state to not enforce any of the challenge laws that were temporarily enjoined by this order until a final judgment in this case. So I'm not sure why we're here today.
So, okay, I won't ask you that. If we reverse the TRO and remand for more fact finding, each of the restrained laws in here will not be enforced.
Correct, Your Honor.
Yeah, let me back up. Is that in the record someplace?
It is not in the ROA. However, it is on the district court's docket.
Okay, I mean, is there a written agreement to that?
Yes, Your Honor.
And what you're representing is the written agreement is the state says, we're not going to enforce any of the challenged laws until there's a final judgment in the district court.
Correct, Your Honor.
Why isn't what we're talking about now moving?
That's my
Not
exact,
even right. I mean, what are we deciding then?
that is my exact question, Your Honor.
How,
Okay, well,
anybody
well,
request to
maybe
put
we
that in
can
the
get some
record?
enlightenment. I mean,
Have you challenged mootness? Did you raise mootness in your brief?
No, Your Honor.
And why not? In other words, was the court's date of July 2025 set when the briefs were filed? When was it set?
It was set after the briefs were filed. However,
Parties, including the reply brief?
I believe so, but there was a trial date on the calendar. It's just that the trial date was shifted because we added new claims to the lawsuit.
okay. You know, what's the form of the written agreement in the district court record?
It's a stipulation.
Signed by both sides?
Correct, Your Honor.
And neither party filed notice to this court of the stipulation?
No, Your Honor.
And you know you could have done that?
Well, okay.
I am realizing that now, Your Honor, and I apologize.
Or at least additions
Well,
to the
I mean,
record? You could have done additions.
That may be something we need to sort out. I mean, we're not going to get it sorted out today, but that's an interesting development.
Your Honor, the reason I brought up the state's argument that it is hamstrung is that it is essentially arguing that somehow it is prejudiced moving forward because these findings based on the district court's alleged credibility determinations are going to be binding, but that is just not the case. A temporary injunction is determined based on a lower standard, which is likelihood of success on the merits, not actual success on the merits.
The remedy here is the non-enforcement. But if there's an agreement that it's not going to be enforced till there's a final judgment, I'm not quite sure why we're even messing around with this. I mean, why we are. I mean, why are we?
I have the same question, Your Honor.
I mean, it's a lot of reading, as Mr. Martin pointed out.
I've already done all the reading, but I mean, well,
Well,
okay,
Ask
we've
Mr.
talked to you about it. You got something else you want to tell us? I mean, you got other questions?
no,
Okay.
Thank you, Your Honor.
Martin, come on up here.
I think you might know the first question.
When was the stipulation filed?
I mean, is there such an agreement?
And why are we now hearing about it at 11 o'clock, an hour into argument?
Your Honors, this agreement was entered in negotiations for the sake of expediency in the trial court and to come to a agreement onto, how the timeline that should proceed. The reason this is still significant is because the credibility finding that occurred here, the legal error, needs to be explained for the sake of, first, the experts going forward.
I'm gonna stop you right there. Counsel, you had a chance to address the district court's a little frustrated, okay? You had a chance to address the district court's legal error, as you said, in a motion to modify, but instead you filed a notice of appeal when you still had time to file a motion to modify. Then you'd entered into a stipulation with the plaintiffs, did not notify this court, and now are asking us to decide a ruling, which you said the district court made a mistake on, despite the fact that you're going to have a full evidentiary hearing a year from July 2025. Where
Go ahead.
do we rule on moot issues? Do we exercise opinions like the Attorney General office issues opinions that have, what bearing would our legal opinion have at all? If the district court judge gets our order and says, okay, and then he has his full evidentiary hearing.
Your Honor, I'm not sure exactly how negotiations would proceed onto enforceability of the Women's Right to Know Act in the interim. But the reason this is significant is because this preliminary injunction was based on a credibility finding that was in fact a legal error.
Okay,
And-
but let me stop you. I mean, I got that's your argument. I want to, and we aren't going to answer it today. I just want to make sure I have some general sense. Is there a stipulation, to your understanding, in the district court record that the state will not enforce any of the provisions that have been enjoined until there is a final ruling? And I mean, presumably that would be a permanent injunction that's adverse to the state, or at least until the judge issues a final ruling one way or the other.
I believe that is the agreement that the parties entered into as to the stipulation on the record.
May it please the court, I'm going to act a little bit out of order here. And
Yeah, well, that's,
the
you
counsel,
are, but
but
go ahead.
I think it's important that I answer these questions because it was based on my judgment and my authority to enter into the stipulation. This stipulation, I think, was only finalized a couple of weeks ago. Now, you probably got me that we probably should have informed the court, but understand that this act has been in effect for 25 years. In this court, in the district court, entered a sweeping injunction against.
Parts of,
Well,
okay,
no, not parts of it. The
No.
whole thing, the whole thing.
not the reversibility part,
No,
not
Yes,
the HB part.
the whole thing, the judge issued an injunction against, and then while we're up on appeal, the briefs have been submitted, the plaintiffs amended their complaint to deal with the very new statute, which regards to requiring women to be asked about. That's a new part of this litigation now. This is not before you, but that was a new issue that they brought to the court in July. So we're faced with a judge that ruled against us down the line with, I think, very shallow reasoning.
Okay. so
We're
this is
confronted,
strategic-
we're confronted with a judge that's not with us. It doesn't appear. We're in a difficult spot. We need the opportunity to present an adequate record to the district court for the purpose of a meaningful appeal, which we didn't have. If you've read the recent HODIS decisions, we did not have that adequate record in those particular cases. So it's my determination to have an adequate record. We needed time to do that.
Okay, all right.
Hence the delay. The only way we were going to get a favorable.
Hang on, Judge Powell.
Okay, the only way.
No, wait. So, I mean, what you're talking about is developing an adequate record in the district court
Correct,
on a final injunction.
correct.
Okay. In the meantime, there's apparently this stipulation.
Yes,
that
to get
the
a
state's not going
favorable,
to enforce any of this stuff.
get a favorable calendar to present our record, we had to make an agreement to
All right.
those.
And trial strategy.
That's-
Get it.
That was the
okay,
difficult
fine.
thing that we're under.
I understand that.
I just don't want to leave this court with the impression that we're wasting your time up here. That's
Well-
not what we're doing. I understand the legal
It's
niceties, but to have an injunction against a statute that's been in effect for 25 years, that the people of this state passed overwhelmingly
Well, no.
on the basis.
Okay, Judge
just hear me
Powell,
out,
no.
Judge.
Judge Powell, hang on.
Hold on one
I'm going to ask a question. I get to do that. You're on the other side now, okay?
I understand.
All right. And we're going to have to sort this out. We aren't going to get it done today. The temporary injunction is simply a placeholder until there's a final ruling, regardless of what we do with it. And you're saying, I mean, if there's an agreement that it's not going to be enforced until there's a final ruling, that's functionally the legal equivalent of a temporary injunction. And I don't know why then it doesn't make moot what's in front of us. And you can go back to the district court and put on your experts as live witnesses and all the other evidence you want. And you will maybe persuade him in that final injunction hearing that he messed up, and that's fine. But I'm not sure why
I'm not convinced that we couldn't, if we were to just acquiesce on this appeal, couldn't that be used against us below? I think it might be able to be used against us below.
Okay.
We're not going to acquiesce to a hostile finding from the
I'm not
district
asking
court.
you to acquiesce. Let me get actually a little bit more specific, because I've been really sort of honing in on this. What's the remedy here? What's the remedy? Because I see the problem you're wanting to address here is you're wanting for us to sort of smack the hands of the district judge to say, hey, you need to really look at this and really consider it and don't look so one-sided. Okay?
Yes,
it
that's
seems like-
exactly right.
Okay, I get it. All right, so here we are, cards on the table. So let's say we do that by sending it back and saying, hey, do a better job. I've got all these kids at home and I'm like, oof, your handwriting here is terrible. Redo this. This is terrible. Why would we need to reverse the TRO in the meantime? I mean, that is what seems a little bit disingenuous here about this argument. If you're saying, look, this is so far afield of fairness that we need a fair shot at the district court, please help us here. That's an argument. But saying that we would need to reverse the TRO when you have a stipulation to not enforce it in the meantime seems...
You got me, Judge.
Amy, I appreciate that you viewed that you were in a, I'm sorry, I've interrupted.
No. Hey, listen, he said, you got me, Judge. I just want,
Judge,
let's
but,
say that like,
we just
You found yourself in a difficult tactical
very
position and made a
difficult
decision.
position.
get that.
Okay.
We're in a tough
And I appreciate
I was
that's-
there at that hearing in front of the district judge. Okay, he pummeled us with questions. I think he asked the other side one question. So
Well,
we've got.
and
a
that's why I'm glad I'm a
We're
judge
litigating
and not a litigator anymore.
Right, we've all
because
been
you
there.
Find
We
yourself
get
in tough spots.
We're in a tough
But
spot.
it seems to me, and again, we're not going to sort this out today. I mean, you can see what's coming. There's going to be some kind of a show cause order, I think. It seems to me that we're in a position that this appeal may very well be, it's either moot or it's not right, given perhaps, given the stipulation. And I think I mean, I can't speak for my colleagues. I think we may want that to be addressed further. And and we're not going to settle it here today. And I appreciate that you made the Attorney General's office and the other made a call about how to best to proceed in the long term. But I think it has left us kind of hanging out where we're being asked to do something that's functionally an advisory opinion. That it's not going to have any legal effect unless you pull the stipulation, which I don't think you could probably do appropriately.
Stipulating to not enforce the law to gain some advantage in terms of trying the case is not the same as acquiescing to a hostile injunction that we think was wrongly decided and not properly supported with adequate findings.
I think there, if you have arguments for why it is ripe and not moot, and as a hint
We'll be
to
happy
that,
to opportunity and
as a hint,
if that's
as a
what you're gonna
hint to
do,
that,
Well, I
I
don't know.
wouldn't,
do that.
I wouldn't maybe argue that you need the TRO reversed, because in order to reverse the TRO, we're gonna have to decide the legal merits of the TRO, and then we're gonna have to do the whole thing, I think. So,
Do you expect after this argument, I apologize.
no, it's okay.
Do you expect after our argument to file the stipulation with this district court, or are we just supposed to assume what's in it?
If the court is asking us to do that, we'll do that.
Okay.
Well, yeah,
I just don't want to assume things that are in there because I understand this trial strategy that you've made. Completely understand that.
We'll need to sort this out. I mean, and
we're-
again, we're not going to get it done today. I mean,
If
we
you
need-
want us to go ahead and submit that
well, we need to,
stipulation,
I know,
or
this
you want
is-
to ask for that, I'm willing
Well,
to do whatever you
I
want.
mean, I think we need to, I mean, you know how we work. I mean, we're not going to rule on anything from the bench here.
Gotcha.
Like kind of, this isn't Law and Order. That's almost before your
You know,
time.
he's referenced
But,
a great movie
All
and a
right.
great TV series.
Oh,
Wait, stop,
Why
stop,
is this
stop.
getting weird here?
No, wait, I'm going to ask her to sit down, Mr.
No,
Atchison.
but
This
There's
is-
an inaccuracy in what's been represented to the
Oh,
court.
we're going to let you do a SIR rebuttal, if you don't mind. I would like to hear from Mr. Judge Powell first and let him have a chance before you stand up. This is not just a court, this is an appellate
this
court.
is, I mean, this has taken an very odd twist. I mean, it wasn't,
Powell.
And it started with me. It's my fault.
Well-
because
It's fine.
You were asking counsel the questions. He wasn't part of those negotiations.
All
I
right.
felt in candid to
So,
the court
I
that I
mean,
needed to come forward. So
I
I
think we've
appreciate that,
gotten
Judge.
about as far as we can get with
All right.
that piece of it. You got a couple of minutes for rebuttal. I mean.
I'll sit down then.
Yeah.
Thank you,
please.
Judge.
And I will listen to whatever it is you want to tell us, but this has gotten very weird, very fast. I guess weird is not quite the right word to use these days. It's gotten unusual. Weird has political connotations now, but I'm sorry. I mean, I'm kind of laughing because otherwise I'd be crying. This is a very serious case. It's a very serious issue. I don't mean to make light of it, but this has gotten procedurally very confused at this point, and we're going to need to sort it out. Putting that aside, give me a couple of minutes of rebuttal that sum up your argument. And we'll listen over here just because we're going to listen. Go ahead.
I'll just raise a couple of points, Your Honor.
Thank you, Mr. Martin.
First, I'll just bring up that the plaintiffs stated a couple of situations where the district court did make findings as to abortion pill reversal, as to whether or not a fetus can experience pain and at what point. I would just argue that even though there were a few disparate positions where those conclusions were explained, they are overwhelmed by the credibility determinations. And when there is a credibility determination, that instigates the deference. And just like in Campbell and Andrew, there were situations where the court explained its analysis, but it still gave deference because there was also credibility. So and then the other point I would just like to bring up is the plaintiffs brought up that the outcome would be the same in this decision because the court relied on uncontroverted evidence. I would just point out that the uncontroverted evidence that the plaintiffs bring up does not come into the compelling interests analysis hardly at all. When what the evidence that we are bringing up is the evidence that was used to support whether or not there were compelling interests, and that was almost entirely rebutted evidence. And so the two sides of the experts do matter in that situation. And I'll just leave it at those 2 points, Your Honor.
All right, thank you.
I have one question.
Yes, Your
Let's just pretend like the last 15 minutes haven't happened, okay? Whose burden was it on this case?
It was the plaintiff's burden to show a likelihood of success on the merits.
Okay, thank you.
There are no further questions.
All right. You're Ms. Woody, correct? All right, what do you want to tell us?
I just want to briefly explain to the court a little inconsistency in the record as Judge Powell just described it. There was a stipulation early on before the amendment for the additional claims were filed that said the state would not enforce any of the new reversal law or the old women's right to know law. And that was entered into the record prior to this appeal being filed, I believe. Now, when the appeal was filed, plaintiffs saw, I think as Judge Hurst mentioned, that it was something where the defendant was asking for more explanation. And although we disagreed with that, it didn't appear to us that they were asking the court to reverse the TRO. Then we get here today and we hear for the first time in this argument that it appears that the defendant is asking for the TRO to be reversed and, in fact, for the laws to be enforced. And I believe Mr. Martin said something to the effect of, well, it's important because now we're not being allowed to enforce these laws. So at that point, we thought we had to bring up this stipulation. Now, it's true that there is another stipulation that's been entered into with respect to the newest law, the law that would have them ask all these questions. So I apologize to the court. We didn't understand the other side to be asking for the TRO to be reversed and taken off the table. So that's all I wanted to say.
Well, and that's just made it more confusing to me. Is there a stipulation in the district court that's not part of the appellate record that the state's not going to enforce any of the enjoined?
I believe that to be the case.
Okay. All right. Well, we're going to sort it out, but all right. Thank you. Anything else you want to add at this point?
Judge, the only thing I'd say is, yes, we agreed the stipulation to not enforce pending the resolution of the temporary injunction. So while this case was sitting up here, fully briefed, plaintiffs sought to supplement their complaint with additional, to challenge a brand new statute that was passed by the legislature.
Okay.
And that's where we were kind of forced to, either litigate when we really weren't ready to prepare, or in an effort to get a better schedule to fully litigate it, we had to.
Okay. Like I said, we're not going to sort that out today. We're going to talk about it and we'll figure out something. I think you will be hearing from us, but we'll get to the bottom of it. I'm going to say I appreciate the argument. This has just been a very unusual morning. We will take the case under advisement and proceed accordingly. I appreciate you being here. And I do want to reemphasize, we appreciate, this is a very serious issue and we are taking it very seriously. It took an odd twist here about 45 minutes in and we'll figure out where we're going. With that, we're adjourned. Thank you. Powell, nice to see you. Nice to see you all.